Hello, uh, I hope you're well. So, these are recordings as I promised. So, I'm going to send recordings in civil in all the 5 core subjects. So, we are going to start with civil today, and I'll do civil from the beginning, from first term up to where you are now. So, up to execution. Now, what you should know, what is very key, is that you should understand that civil is governed by the Civil Procedure Act, the Civil Procedure Rules, Civil Procedure Act Cap 71, the Civil Procedure Rules Statutory Instrument 71-1 as amended, the Magistrates Court Act Cap 16, of course the magisterial areas, High Court circuits, the Judicature Act Cap 13 as amended, Judicature Court Fees and Fines and Deposits Rules, Statutory Instrument 13-3, the Evidence Act Cap 6, the Limitation Act Cap 80, and of course the Constitution, of course Advocates Professional Conduct Regulations, Advocates Remuneration and Taxation of Costs Rules, the Government Proceedings Act, Civil Procedure and Limitation Miscellaneous, the Local Governments Act, the Contracts Act, all that, you know the laws. But mainly, when we're talking about civil, we have to start with what they call jurisdiction. Jurisdiction is before you think about instituting a suit and thinking about the matter, we'd look at where are you going to institute the suit. Then we can come to who are you going to sue. That will be parties. So let us start with jurisdiction. You know that jurisdiction is the one that confers power upon courts. Jurisdiction has pecuniary jurisdiction and geographical or territorial jurisdiction. Pecuniary jurisdiction being the monetary value or the money value, or how much the subject matter is, or how much the case is. And then geographical being the area you're going to go to. That's why you see magisterial areas and high court circuits. You all know that the high court in Uganda, that's why they say the high court in Uganda, high court is only one. Then at somewhere at Kampala, so it's only one. So jurisdiction, you would look at a case, because what I want you to do when you're listening to this recording, I think you should have your workshops with you, so that you can always refer to the cases, because I always put in cases, I always refer to cases. So you should have them with you. So when you look at the case of Desai versus Warsaw, 1967, East Africa 351, you realize that Desai is DESAI versus Warsaw. War is WARSOSAW. 1967, East Africa 351. I'm not going to read the spellings of the cases, but I'm going to tell you the number on your workshop. It was number 21, case number 21. Now in that case, what happened is that the primary court of Tanga entertained a claim to recover a sum of 1,500 being house rent plus. But the principle in that case is that what court held that no court can confer upon itself jurisdiction. What are we saying? If a court is not vested with jurisdiction to entertain a matter, then it cannot entertain a matter. So that's a leading case. So I would look at, let me first start with pecuniary jurisdiction. That is the value of the subject matter. Pecuniary jurisdiction, we shall look at sections, Article 139 of the Constitution, 1995 Constitution of the Republic of Uganda as amended, and Section 14 of the Judicature Act, Cap 13, Section 98 of the Civil Procedure Act, Cap 71, Section 33, I think, and 34, I think, around there. Those are the sections that give the High Court unlimited jurisdiction. What does it mean? Remember, I told you we are starting with pecuniary jurisdiction. What does it mean? That the courts now, High Court has powers to listen to a matter, whether it is 1 trillion or 10 trillion. So it has unlimited jurisdiction when it comes to the value of the subject matter. Now, for magistrates' courts, it is Section 207 of the MCA as amended. MCA is Magistrates Court Act, of course. The chapter is Cap 16 as amended, because it was amended. Most of you have acts which are not amended, because when you look at Section 207, you will find that for magistrate grade 1, yours is still at that they cannot entertain a matter which exceeds 2 million, but the amendment is 20 million. So a magistrate grade 1 is 20 million. So where a matter is 20 million shillings, he can entertain it. For chief magistrates, it is 50 million. So that is the pecuniary jurisdiction. Okay. So I'm going to look at different scenarios on pecuniary jurisdiction. Let's look at where matters are joined. If matters are joined, if the causes of actions are joined, for example, under order 2, rule 4, which is on joinder of causes of action. When you read order 2, rule 4, sub rule 2, it talks about joinder of causes of action. And so I'm looking at the pecuniary jurisdiction where causes of actions are joined. So when you look at order 2, rule 4, sub rule 2, you will realize that it states that where causes of actions are united, the jurisdiction of the court as regards to the suit shall depend on the amount or value of the aggregate subject matter at the date of instituting the suit. What am I saying? That if X has instituted a suit of 20 million and Y also a suit of 60 million, so when you add the two, it is 80 million, meaning that matter will straight go to the High Court. But if it was only X, then it would be magistrate grade 1 because it's 20 million. Or if it was only Y, it would go to High Court. Why? Because as long as the matter is above is 20 million, it's magistrate grade 1. If it's 50 million and below, it is chief magistrate. If it is above 50 million, then it is the High Court. So where the causes of actions are joined, then the average, when you add the two, the amount will determine which court to go to. Let us look at pecuniary jurisdiction in award of damages. You remember I told you that pecuniary jurisdiction is about the value of the subject matter. How much is your suit? How much do you need? If it's land, how much is the land? So if it's 20 million, you go to grade 1. If it's between 20 to 50, chief magistrate. If it's above, High Court. So pecuniary jurisdiction in award of damages. You look at the principle is that for pecuniary jurisdiction in award of damages, the principle is that everyone must stay in his line. What am I saying? That for magistrate grade 1, you can't award damages above 20 million, above your pecuniary jurisdiction. For chief, you can't award damages above 50 million. Okay? So that is what it is when it comes to award of damages. And there is a case which was which was to that effect. That is the case of National Medical Stores versus Penguins. Like you hear Penguins Limited. Penguins is Penguins Limited. High Court Civil Appeal number 29 of 2010 and reported. And what happened in that case is that a magistrate grade 1 awarded damages of aggregate damages of 59 million. That is grade 1. And court held that a magistrate cannot award damages over and above his or her pecuniary jurisdiction. So let us look at pecuniary jurisdiction regarding award of costs. What happens if courts are awarding costs? Do they go beyond their pecuniary jurisdiction, that is the subject matter, the value of the subject matter, or not? Now, in the same case of National Medical Stores versus Penguins that I had given you, it was held that it is a settled principle of law that costs are not considered in determining pecuniary jurisdiction of a particular court. And they continue to say that hence a magistrate can award costs which exceed the pecuniary jurisdiction of a presiding magistrate, provided that they were incurred, those costs were incurred during the course of litigation in question. All this I'm talking about is regards pecuniary jurisdiction of magistrates courts, because High Court has unlimited. So I'm looking at pecuniary jurisdiction of magistrates courts. So let us look at pecuniary jurisdiction as to the award of interest. Okay, when it comes to awarding interest, can a magistrate go above his pecuniary jurisdiction? And in the case of UCB, that's Uganda Commercial Bank Limited, versus Yoram Twala. Yoram is YORLAMU. Then Twala is TWALA. High Court Civil Revision number 16 of 1998. It was held that the interest on the decretal sum is not part of the subject matter for purposes of determining pecuniary jurisdiction. That means they can award any interest, even if it's above the pecuniary jurisdiction. Okay, now let me cross to geographical jurisdiction. Remember, we looked at pecuniary. Now let me cross to pecuniary jurisdiction. Let me cross to territorial or geographical jurisdiction. Okay, so what you should know is that suits should be instituted conveniently within the local limits of where the cause of action arose, or where the defendant resides, or where the subject matter is situated. Section 12 of the Civil Procedure Act provides that suits will be instituted when it comes to immovable property. You're going to forgive me because I'll be opening these acts, since this is a final recording. I have to make sure I have the right thing. So when you look at section 12 of the CPA, it says suits to be instituted where the subject matter is situated. And it says that subject to the pecuniary or other limitations prescribed by any law, suits for recovery of immovable property with or without rent or for profits for the petition of immovable property. So it's from A to E shall be instituted within the local limits of whose jurisdiction the property is situated. Okay, so for those suits, it's where the property is. But when you look at section 13 of the CPA, that is the Civil Procedure Act, you realize that it is on suits of immovable property situated within jurisdiction of different courts. What am I saying? If you have an immovable property, for example, at a border of Kampala and Impigi, so you have it is the other side and this side. So we would look at where would you institute, which court would you go to if it's immovable property. So you have land that crosses the border to another district, from one district to another. And in that case, section 13 is your answer. That is that it can be instituted in any court within the local limits of whose jurisdiction any portion of the property is situate, if the respect of the value of the subject matter of the suit, if in respect of the value of the subject matter of the suit, the entire claim is cognizable by that court. So what are they saying? You cannot go to magistrate's court when the value is 60 million now. So also the value will come. Then when you look at suits for compensation of wrongs to persons or immovable property or movables, that is section 14. So the issue is, which court would you go to? Remember, I'm talking about geographical jurisdiction. And the thing is that if the defendant resides in one jurisdiction and the cause of action arises in another, then it is at the plaintiff's disposal to choose where to institute the suit. For example, if a person boxes you from Mukono and resides in Kampala, you can either sue him, you can even bring the cause of action in Kampala or in Mukono, where the cause of action arose or where the defendant resides. Consider sections 212 of the Magistrates Court Act, which is also to the effect that suits to be where the subject matter is situated. And also section 215 of the Magistrates Court Act, which says other suits to be instituted where the defendant arises or where the cause of action arises. I know I might make mistakes of these sections, so you make sure you open there and read them. Don't follow what I'm telling you. That is a disclaimer. So you make sure you open those sections and read them, because I might have an oversight. And then you start blaming, you're just saying I'm giving you the wrong thing. So this recording is a disclaimer that follow it at your own peril. I mean, make sure you read what I tell you. Is it true? If it's not true, don't follow it. So the next thing I would consider is what happens in suits where the cause of act, where it is contracts. We are looking at geographical and territorial jurisdiction. So what is the geographic and territorial jurisdiction if we are talking about contracts? Okay? And in that, they say if a suit is concerned with a contract, the cause of action is said to arise where the contract was made. That is the first thing. Or where it is to be performed. That is the second thing. Or where the contract of payment was to be paid. So there are three things when it comes to contract. So you can sue, or you can institute a suit in a court where the contract was made, or where it has to be performed, or where the contract of payment was to be paid. What am I saying? The contract might have been made in Kampala, but to be performed in Mbarara, or payment to be done in Gulu. So you can choose any of the three, and that is where you can go to the court you go to. And the case is the most important case there is the case of Sebagala and Sons Electric Center versus Kenya National Shipping Lines, UCL in brackets 1997 to 2001, close brackets, at page 388. In that case, that is what was stated. What happened is that the plaintiff, whose Sebagala, contracted the defendant to transport its goods from UK to Kampala via Mombasa. So the goods were to be handed to a clearing agent appointed by the plaintiff. When the goods arrived at Mombasa, the Kenyan Port Authority released them to another person, another company, and as a result, the goods were lost. So the plaintiff sued the defendant in the High Court of Uganda at Kampala. So one of the most important issues was whether the Kampala court has jurisdiction to hear the suit. because these people were claiming it should have been in Kenya, not Uganda. And the court held that when it comes to matters of a contract, suits can be instituted where the contract was made, or where it was performed and completed, or where payment was effected. Okay, that is what we are talking about. So now I'm going to jurisdiction of High Court in international matters. Okay, so jurisdiction of High Court in international matters. When it comes to international matters, we look at it is dependent on the parties as they are at will to decide which jurisdiction will prevail if a dispute arises. So what am I saying? If you're drafting a contract, like a sale agreement or whatever, you always put the last thing, governing law. So you can either say that it will be the laws of England that will govern us, or the laws of Uganda, or the laws of Kenya. So if that is stated clearly, that means you cannot institute a suit in a country which you did not subject yourself to. So let us look at what happens where the parties don't mention the court of jurisdiction. That one is very simple. It will then be determined where the cause of action arose, or where the defendant resides. Okay, so what happens we are looking at jurisdiction, geographical. What if one of the parties is a state? Okay, what happens? So when one of the parties is the state, it can't raise argument that local limits have no jurisdiction cause of immunity. Okay, so the principle is that when you look at the case of Eddie Rodrigues is Rodrigues versus the British High Commission, Supreme Court Civil Appeal number 8 of 1987. It's unreported. It was held that if a government or one of the departments goes into a marketplace of the world and engages in straightforward transaction, then it is within the territorial jurisdiction of the courts of the sovereign. So the sovereign can't claim immunity in respect of such transactions. Okay, so if an ambassador gets engaged in his private things, he cannot claim that because he acts on behalf of the state. So let us look at jurisdiction now by subject matter. Okay, jurisdiction by what? By subject matter. So you will see commercial division entertains all actions arising out of any relationships of commercial or business nature. The family division handles divorce, adoption, children's rights, and other related matters, inheritance. Why am I saying this? Because most of the times you can reach an oral panel and they ask you, tell us what does the family division handle, or commercial division. The land division, it's land disputes. So these are divisions. The civil division handles all other civil matters that are not designated to the other divisions, okay, above, such as electoral petitions, defamation claims. Then the execution bailiffs division, which was there, now it was suspended, it was removed. Before, there was an execution called the bailiffs, which would handle matters relating to enforcement of court orders, execution of court decisions, and operation and regulated operation of court bailiffs. But that division was removed. Now each court can do what? Each court can execute its own decree. So the execution and bailiffs division is no longer there. It was suspended. Okay, what happens now? Well, the next question is, what happens where a suit is filed in a wrong division? So in that matter, the suit is transferred, but the errant party may be penalized in costs. But what you should know, what is important to note, is that this depends on whether the party is still within the time prescribed by the law. So the matter cannot be transferred if it is out of time. So it's subject, that transfer is subject to limitation. the limitation period. Okay, for example, if you are to file a defense let me assume you have been given 15 days to file a defense. Remember, they have sued you in the civil division and you file a defense in the land division. So you write to the registrar of the land division informing him that you made a mistake, you filed in the wrong division. They transfer it to the civil division, but that should be within the 15 days. So beyond 15 days, it cannot be transferred because you are out of the time you are supposed to file that defense. So if you want a transfer to happen because you have filed in a wrong division, then it is